Well, good afternoon, everyone. My name is Madeline, and I'm going to be presenting on things to know on the commitment process in the state of Florida. So, just a quick overview. I'm going to be discussing the history, the voluntary admission process, the involuntary examination process, admission to state hospital, and the transfer process, as well as rights of persons under the Baker Act. So this is a really big topic. It's a very lengthy topic. Typically, this training is given over 8 hours. So I've just kind of cherry picked the really important things to know about the Baker Act. So to start us off, the Florida Mental Health Act is commonly known as the Baker Act. The Baker Act serves to ensure due process for individuals with mental illness. And this excludes certain things such as substance abuse, which is covered through the Marchman Act, and developmental disabilities, which is things like autism and intellectual delays, which is covered through the Developmental Disability Statute, which is Chapter 393. The Baker Act can be initiated in conjunction with these other two, but typically, which does happen often, but the person still has to meet criteria for the Baker Act. So essentially, the Baker Act covers only psychiatric examination and psychiatric treatment. So why the Baker Act? Maxine Baker was a legislator from Miami who was part of the legislative committee in 1971 that focused on revamping the then 97-year-old mental health statute. So the biggest concern of this old statute was the lack of due process for people with serious mental illness. The right to treatment was always available, but the involuntary treatment process didn't have any protection, which is now part of the law offered by the court. So the law is, adjusted frequently. It's been adjusted multiple times since it was implemented in 1972. And it's always concerned with balancing a client's liberty with their safety and the safety of society. So who is protected under the Baker Act? The short answer to that is everyone. Anybody who is being treated for a mental illness in the state of Florida falls under the protection of the Baker Act. So this covers people who are voluntary and on involuntary status, inpatient and outpatient, people of all ages, those that are competent or those that are deemed incapacitated. And it includes both private and public receiving facilities, state hospitals, anywhere anybody is treated for a mental illness is protected under this law. And so what is a receiving facility? Unless designated by the Department of Children and Family, facilities are not permitted to hold or treat persons against their will or without their express and informed consent for mental illness, except as it's required by federal and TALA laws. So a receiving facility is any public or private facility designated by DCF, and they are able to hold a person on involuntary status under emergency conditions for psychiatric evaluation. So a receiving facility essentially must be able to provide on-site emergency reception, screening, and inpatient treatment services 24/7, regardless of the patient's ability to pay. They have to be able to accept patients of all ages. They have to assess all persons for clinical safety, co-occurring disorders, substance abuse, physical and sexual abuse, and trauma, and all hospitals must comply with federal and TALA laws as well. So if a patient is in the hospital for medical reasons, let's say a car accident or any such thing, and has also been Baker Acted, the facility is not a receiving facility, the person must first be medically stabilized and then transferred to a receiving facility. And there's a 12-hour window for this transfer process, typically. I've noticed in my experience in a receiving facility that 12-hour window is not typically met because there's a shortage of available beds and spaces in receiving facilities, and so there is often a longer wait to be able to be taken to another facility. So the voluntary process. Of the entire process, this is possibly the smoothest, the easiest that transitions in. First, it discusses the criteria. Voluntary admission for adults means the individual has a mental illness as defined by the Baker Act, and that they're suitable for treatment, and they must be able to provide express and informed consent. So I'm going to go into what express and informed consent a little bit later, but that's a very important part of being a voluntary patient in a psychiatric facility. So what is mental illness according to the law? The Baker Act law outlines mental illness as an impairment of the mental or emotional process, such as a thought disorder or a mood disorder, that exercises control of a person's actions or their ability to perceive or understand reality. These are very serious conditions such as schizophrenia, bipolar, major depression, and conditions that include psychotic features. There also has to be a substantial impairment in meeting the everyday demands of living. So substantial impairment will depending, on the person's daily activities. For a minor, that's going to be different from an elderly person or from somebody with typical functioning. So again, we go into what consent is. So for express and informed consent, it must be given in writing by a competent person after sufficient explanation has been given and disclosure as to what the treatment is going to be. And they have to be able to make this decision willfully and knowingly and without coercion. And so that's a really important part of what it means to meet criteria for voluntary admission into a facility. The law offers special protection for the elderly. Specifically, this protection is for elders in long-term care homes, such as a nursing home or an assisted living facility. These patients can't be sent directly from the long-term care home to the emergency department or a receiving facility without the initiating status being started in the facility that they originated in. So this specifically, it applies to elders on voluntary status that are 60 years old and older. For this population, an initial assessment must be performed in order for the individual to provide express and informed consent. So this can be done by either a mental health overlay program, a mobile crisis response service, or a licensed professional from a community mental health center. And they will then go to the receiving facility, be it a nursing home or an ALF, and assess the patient prior to then deciding whether they meet criteria for voluntary admission. For discharge of persons on voluntary status, it's important that voluntary patients know that they have the right to request a discharge. So the notice of right to request a release is given to them at the time of admission. When a person requests the right to release, the notice must be presented to the psychiatrist within 12 hours, and the person must be released if they are granted the release within 24 hours. If the patient refuses treatment or revokes consent, they must be discharged within that 24 hours of refusal. Typically, what happens in our facility is if a person decides to request the right to release, it is presented to the psychiatrist. The psychiatrist will then reevaluate the patient and decide whether they meet criteria for discharge. Very often, the patients don't, and so the involuntary commitment process is started. And I'll go over that process a little bit more in a few minutes. So in that case where a person is voluntary and then goes to involuntary status, the receiving facility then has 2 days to file a petition with the circuit court to petition for involuntary inpatient examination. So the involuntary examination criteria outlines what a it includes the criteria for mental illness. So essentially, it includes multiple components. There has to be a reason to believe that the person has a mental illness. And due to the mental illness, they are either refusing treatment or unable to determine that they need treatment. And they also have to be at risk for suffering from neglect or refusal for self-care, And as a result of that neglect or that refusal, they present a real threat, a substantial threat to their well-being. Also, there there has to be a likelihood for serious harm, to self or others. So they have to have a mental illness, and because of this mental illness, they don't know or they don't understand that there needs to be an examination, and there has to be either neglect or the threat for self-harm or harm to others. Those are the criteria. So initiation. Upon determination that the person appears to meet criteria for involuntary examination, the exam can be initiated in one of three ways. Either the court can initiate it, it can be initiated by law enforcement, or a mental health professional can also initiate this process. So a judge can be either a county or circuit court judge, and certain authorized mental health professionals are also authorized to do so. So now a judge and a mental health professional may or may not choose to initiate a Baker Act, whereas law enforcement officers are, they have to complete it. They are required by law to complete this. This means law enforcement are not expected to be diagnosticians. They are allowed to take credible secondhand witness testimony into consideration when determining if a person meets criteria for a Baker Act. This is often the case in the scenarios that I see, where the police are called to respond to a report, and they're not the ones who actually witness the bizarre behavior or the aggression. But if the source is credible, then they are bound to comply and take the person in for involuntary examination. So the law outlines that certain mental health professionals are qualified to initiate the Baker Act. Some of these professionals are psychiatrists with no less than 3 years of primary experience in diagnosing and treating mental health and nervous disorders. A physician who also has to have experience in diagnosing and treating mental health and nervous disorders. A clinical psychologist as defined by the law with at least 3 years of postdoctoral experience. A psychiatric nurse, which is required to have either a master's degree or a doctorate degree with 2 years of postmaster's clinical experience under the supervision of a physician. And then we have clinical social workers, licensed mental health counselors, and licensed family and marriage therapists as well. And all of those are governed under Chapter 491, which explicitly explain how to become either a social worker, a licensed mental health counselor, or a marriage and family counselor. So only professionals listed under the Baker Act can act. This means that there cannot be a delegation of duties to physician assistants or ARNPs that are not properly credentialed. So transfers in legal status. As I mentioned before, a lot of patients that come into our unit come in under a Baker Act, which means they are transported by law enforcement. Typically what happens is they sit to see the physician and they are asked if they understand all the information that's presented to them, and they're then asked to provide consent for voluntary admission. In this case, the client is going from involuntary status to voluntary status, and essentially they just have to meet all of the criteria for voluntary status. There are occasions where clients will go from involuntary status to voluntary. I'm sorry, the other way around, from voluntary to involuntary. This happens if a patient decides to request release before they're ready to go, or if they've decided to stop taking their medication is another example. And in that case, we then have to initiate the involuntary inpatient petition process. Minimum standards for initial mandatory examination. So essentially the minimum standards are, there has to be a review of the behavior of the transportation form, which is essentially what the law enforcement has to fill out if they are the ones who initiated the Baker Act. whether the person came in as an ex parte, which is a legal order, or if they came in as a referral from the mental health professional. So once in the unit, a brief psychiatric history has to be taken, and a face-to-face exam must be provided in a timely fashion to determine if the person meets criteria. In our hospital, we also have a telepsych, so they will wheel a system into the emergency department, and the client will sit and actually speak with a psychiatrist through teleconferencing, and that psychiatrist will often determine if the person meets criteria to be admitted for treatment. The approval for release can be completed by a psychiatrist, a clinical psychologist, or an emergency room physician. And in some cases, it can also be done by a psychiatric nurse. Either way, the disposition must be reached within 72 hours of arrival at the hospital. But this is not inclusive of any time that they spent needing to be medically cleared. So it's that time really starts after medical clearance. So the involuntary inpatient placement. This process here is the petition filing process here is the process that I am most involved in where I currently work. As the Baker Act coordinator, I am in charge of filing all of the petitions and following up with the state attorney and the public defender for patients that are in the unit and need to go before the court for involuntary inpatient placement. So for criteria, they also have to meet the criteria, the same criteria that was stated before. They have to have a mental illness. And as a result of that mental illness, they are refusing placement for treatment, either because they don't understand that they need treatment, or they're unable to determine that they need the treatment. But there also has to be that imminent danger component. So either they have to be at risk for neglect, or they have to be at risk for serious bodily harm to self or others. So essentially, they have to meet that criteria in order to be able to qualify to be inpatient involuntarily. But also, all less restrictive treatment alternatives have to have been explored, and they have to be deemed inappropriate for the person to be able to be involuntarily committed to a facility. So the petition filing process is a rather lengthy process from beginning to end. We have 72 hours from the time that the patient comes into the unit and is determined to be involuntarily admitted, to have two doctors, two physicians complete a first and a second opinion for the court filing process. The petition can only be filed by the administrator or by a designee for the facility. In my facility, I am the designee for filing. And the recommendation or the first and second opinions from the physician, they have to be explicit in the information that they include, meaning they have to be information that supports their decision to involuntarily commit a patient. So we have 72 hours from the person's arrival, with no exceptions of weekends and nights. So this is sometimes a problem in units, or in our unit, when a patient arrives either on the weekend or late at night, and the first opinion is done on, let's say, a weekend. It sometimes is a challenge to have two physicians to fill out the opinion to be filed with the court within that 72-hour window. In the state of Florida, there is no fee to file this petition, and we are able to do it online, which is a nice change. A couple of years ago, all of these petitions had to be filed by paper and in person. So the online filing process is much more streamlined. After the petition is filed with the circuit court, everybody gets a copy of this. Person in the hospital, the patient gets a copy, their representative, the state attorney, the public defender, and the Department of Children and Family. And so the petition must be filed in the county in which the person is hospitalized. So in this case, it would be Miami-Dade. And then they give us a time, a place, and a date, a time, and a place for the hearing. So in Miami-Dade, all of the hearings are held at the University of Miami Behavioral Health Building, and so all our patients have to be transported from our facility to that facility for the court hearing process. So each person is entitled to independent expert examination. If an independent expert is required and they can't afford one, then the court provides one. The examiner is kept confidential unless the client decides to call this person as a witness. So the patient, the representative, or the administrator, they are able to apply for a change of venue. It's typically unlikely because it extends the amount of time that the court date happens. So I've never seen it happen, but I know that they are able to provide a change of venue. Within 1 day of filing the petition, a public defender is appointed to represent the person if no other counsel is obtained. So as part of the patient's defense, the public defender is allowed access to the patient's medical records, any witnesses, to the patient themselves. The public defender typically coordinates with me to come and visit the patient, and I will then provide him any information that he may need once he's in the unit. Once the petition has been filed, the state attorney's office will then contact me to schedule the court date. The court date is usually held within 5 business days unless a continuance is requested. So the patient has the right to request at least one continuance of up to 4 weeks. Again, most times this doesn't happen because patients are pretty eager to want to leave the hospital, especially if they're being brought to court for involuntary inpatient placement. So a patient can choose not to attend their hearing, but this does not mean that the hearing does not happen. I've seen that happen on a number of occasions where the patient is not well enough to be transported, but typically patients will attend their hearings. A judge or a magistrate presides over the hearing. And just to note, the difference between a judge and a magistrate is that a judge is elected and a magistrate is appointed. In Miami-Dade County, we have a magistrate who presides over Baker Act hearings as well as Marchman Act hearings. Video and telephone conferencing is strongly discouraged by the Florida Supreme Court Commission on Fairness. So it also has happened where a physician can call in their testimony, but as I mentioned, that's strongly discouraged, and it has to be in extreme circumstances. The proceedings are recorded and the testimony is provided under oath. The purpose of meeting in court is to provide proof by clear and convincing evidence that the patient must remain involuntarily in a locked facility. This is done by providing evidence that is precise, it's explicit, it's lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter at issue. The patient has a right to refuse to testify during their court hearing. And typically during these hearings, there's a number of witnesses that are asked to join. One of the 2 doctors who petitioned the court are required to be at the court filing, as well as staff from the hospital, family, case managers, anybody who can support the need for the person to be involuntarily committed into the hospital is invited to join them. If the person is considered incompetent to provide consent, a guardian advocate is appointed. If the court finds that a person meets criteria for involuntary inpatient placement, the person can be ordered to remain for a period of up to 6 months. If the person is at a treatment facility, they may remain there, or they can be treated at another receiving or treatment facility. My particular facility is a 23-bed crisis unit, and so typically most people don't stay in our unit to stay for longer than maybe 30 days is the longest. But in the cases where patients are mandated to go to state hospital, we have had patients remain in our unit for upwards of 3 or 4 months, waiting for a bed at the state hospital. So there are occasions where we have patients in our unit for extended amounts of time. And again, the difference between a treatment facility and a receiving facility is that a treatment facility is a state hospital and a receiving facility is a public or private DCF authorized facility. So the admission to state hospital and the transfer process. If a patient is to be transferred to a state hospital, they must first receive a transfer evaluation. So there are multiple agencies that will send somebody from their clinical mental health to evaluate the patient for transfer. The person is evaluated to ensure they meet the criteria for admission and whether they are appropriate, whether there are appropriate, more integrated and less restrictive treatment resources available. Following an evaluation, a recommendation is made for admission to a state facility, or if they don't meet criteria, an alternative treatment program. A transfer evaluation form must be completed, and then all of that information is sent over to the state attorney, to the public defender, and to DCF. So the person must meet the statutory criteria for admission to a state hospital, to a state treatment facility. If less restrictive treatment resources are available and they meet criteria, oftentimes depending on the length of stay at the treatment facility, at the receiving facility, oftentimes they will meet criteria for less restrictive treatment prior to needing to be transferred to state hospital, in which cases the process is not reversed, it's amended so that they are then able to go to a least restrictive facility. If a person continues to meet criteria for involuntary inpatient placement, the administrator must file a petition 20 days before the expiration to request that the patient continue under involuntary placement. This typically happens in the state hospital, but only if they meet criteria. After they have been treated for a certain amount of time and they go past that stage of meeting criteria, they are then discharged from involuntary inpatient placement. For discharge, unless they have a criminal charge pending, if they have criminal charges, then they will go from the facility to law enforcement. Transfer of the person to voluntary status if the person is willing and competent to provide express and informed consent, unless the person is under criminal charge as well. The person may go on to be treated in a community facility and given a discharge of transfer. So a little bit of information about the rights of persons under the Baker Act. So they basically have all of the rights that anybody else has. They have, their individual rights. They have rights to treatment, to participating in their treatment and in their discharge planning. They have a right to give informed and express and informed consent. They have the right for quality of treatment and communication and abuse reporting. So in our unit, we have posters on both sides of the unit that have all of the phone numbers for reporting abuse and the abuse hotline, as well as phones that are available 24/7 for them. They are given the right to care of their personal belongings. They have the right to vote in public elections. Sexual misconduct is prohibited. They have all of the rights under the Florida Patients' Bill of Rights. They are given all of the information in writing and copies to any significant other that they may deem appropriate. They have the right to have access to the phone 24/7. They have access to visitors during the hours posted. They have freedom of movement, which means that we can't restrain them, we can seclude them, except when it's for their safety or the safety of others in the unit, in the case of imminent danger. They have the right to outdoor and exercise at least half an hour a day, unless it's prohibited by physician order. In our unit, we have an outside patio area, and typically they're out there, 3 hours or so, 4 hours a day, with the activity therapist on our unit. They have the right to not be remanded to wear special clothing. So they're prohibited from wearing clothing that would identify them as mentally ill or having any kind of specific disorder. And they're obviously afforded all of the rights under the Constitution. All of my information comes from the Mental Health Program Office and the Department of Mental Health Law and Policy. It's all brought together in this book by the Department of DCF and by the University of South Florida.
Great job, Madelyn. Does anybody have questions?
Yes, I do. This is Grace. I am curious if someone is brought in by at law enforcement, do they have the ability to like call for a lawyer or fight against this involuntary action, assuming that of course they've got some of their mental faculties?
Yes. So they are offered the opportunity to have access to the phones that we have on the unit 24/7. If they have a lawyer that they would like to call, they are by all means welcome. And we do have occasions where somebody will call their lawyer, and we welcome the lawyer and the legal counsel to come and visit with their client whenever they wish. So they don't necessarily have to come during visiting hours. We try our best to accommodate, especially legal counsel, whenever they need it. So yes, it's probably good to note that when law enforcement brings a client into the emergency department, in the emergency department, they're obviously assessed for medical concerns. But at that point, they also see somebody within that first 24 hours. They see a physician or a psychiatrist to determine if they meet criteria. If the initial examination shows that they do meet criteria, they are then brought from the emergency department into the receiving facility, which would be the mental health portion of the hospital, whether it be our facility or an external facility. At that point, once they enter the facility, outside of the emergency department, they're reevaluated at that point as well. That's when that 72-hour window opens up, where the physician must then determine whether they meet criteria for voluntary admission, and if they don't, whether they meet criteria for involuntary placement. And if it's the involuntary placement, then the whole petition process is then initiated.
I have a question too, if you don't mind. I was wondering, I know that you're in Miami, extenuation, hurricanes and whatnot, all of these different weird weather emergencies may happen. What happens on your unit in the case of a hurricane emergency?
So we actually had a hurricane last year, and in cases like that, they typically will lock down the entire hospital. So if we have an idea of when the roads are being shut down, everybody will need to be in the hospital by the time that the roads are being shut down. And then we just stay on the unit with our, we're fully staffed. So we have a set of nurses that will rotate between day and night. And we all stay on the unit. And so last year I was on the unit for our emergency, our hurricane. And every year we kind of rotate that schedule so that the same nurses are not required and the same techs are not required to be there during the hurricane. So they can be the relief after the fact. But I mean, we secure the unit and make sure that, that we're safe. At least in our unit, in our hospital, we have generators and we have places to kind of go if one place becomes compromised. But we have protocols and procedures in place for emergencies such as those.
In your experience, have you ever noticed like a family member who wanted to get their family member off the unit because of a hurricane?
Not because of the hurricane, but we get a lot of family members who do not agree with the decision of the law enforcement or of multiple physicians that have, evaluated their family member, and they insist that these patients be released at times. And it's complicated in those cases, because oftentimes the physician doesn't agree, and the physician is the last deciding factor of when a person is able to go back into the community.
Interesting that they can keep you like that, but I am happy that they do keep enough staff in-house to rotate. Has the hospital ever been compromised?
Not that I know of. Our unit in particular has been open for 7 years, so it's a relatively young unit. So as far as I know, there's never been an issue there.
Thank you for being so knowledgeable and being able to handle all of our questions. I find your topic extremely interesting, and you did a very good job. Thank you so much.
Well, if no one else has any questions, we will take a little bit of time here to kind of relax and regroup after your awesome presentation. And then we do have a 4 o'clock, a 5 o'clock, and a 6 o'clock today. So you guys can kind of pace yourself at this point and jump in for the rest. Maddie, do you have any, or is the PowerPoint going to be available to send out if anyone's interested?
Yes, I actually submitted that on Monday.
Great. Perfect. Okay. Thank you very much.
Thanks.
Thank
All right,
you.
everybody. Have a good one. Thanks so much.
Hello? My tongue's stupid thing.